Hello and welcome to Rajya Sabha TV. I'm Amritanshu Rai and you're watching Constitutionally Yours. In this program, we attempt to demystify the Constitution. Today, we will be discussing and taking up and attempting to demystify the fundamental rights which are fundamental for the Constitution and for the governance of this country. Joining me in this endeavor are a distinguished panel of guests. I have with me Justice T.B. Radhakrishnan. He has been acting Chief Justice of Kerala High Court and has been nominated by the Chief Justice of Kerala High Court. I also have with me Mr. V.D. SATHEESAN, MLA, nominated by the Leader of Opposition. And I have with me VEENA George, Member of Legislative Assembly, Kerala Legislative Assembly, nominated by the Speaker of the Kerala Legislative Assembly. And in the audience, we have students from Government Law College who will be joining us in this discussion. Straight away, and to start off the program, Article 14, essentially it is equality before law. It reads, as the state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. So my question to you is, how can most citizens be equal before the law when you need loads of money to fight a case in High Court and in the Supreme Court?
The equality doctrine in Article 14 of the Constitution, in its practical aspect, sometimes or rather to a large extent gets controlled and watered down because of socio-economic challenges and inability of people to access justice. This is a huge problem which we have. This is why, with the passage of time, the Constitution got amended and Article 39 capital A was brought in to see that none is denied the opportunity to access justice merely because of economic or social or other inabilities.
Sir, the legal assistance scheme that is there operated by the high courts, why hasn't it been able to take off the way it should have? Because that's the only safeguard that common people who can't afford expensive lawyers can fight their cases at the highest level.
In my view, things have improved, or rather it is on the path of improvement. The National Legal Services Authority, the state legal services authorities in all states, and the district legal service authorities and the Taluk Legal Services Committee, they have brought up teams of what's called legal assistance lawyers through the legal service system. What is really lacking is that we need youngsters from the lawyers with more potential and commitment and who are able to work with a dedicated mind and having a purposive approach to get these objects ought to be achieved. Because a person working for providing legal assistance to the marginalized cannot work always for money. It's not money that matters. And the rates at which amounts are being paid to those lawyers have also been virtually doubled. And much more is coming up. And in the Supreme Court and in the High Courts, there are new schemes under which there are catchment areas of good lawyers being brought into the system. But more than this money process, it is the commitment of the lawyers that matter.
Sir, commitment of the lawyers and equality before law, right? You've been a lawyer yourself. You know how the system works. Do you really think a senior lawyer or a lawyer who is well versed with his art and can swing a case right or left according to his arguments will be ready to work for free through legal service assistance? Do you think that's possible?
It's possible. The state is under a constitutional obligation to protect the fundamental rights guaranteed by the Constitution. Particularly, the person belongs to a weaker section and who is unable to fight a legal battle with an influential or a strong opponent who is exploiting him. The lawyers has to do their duty, and it is possible, especially as told by Justice, all the young lawyers come forward for appearing.
But for
the
winning a
weaker
case,
sections.
you don't need young lawyers, you need seasoned lawyers.
But young lawyers, seasoned lawyers not only, the young lawyers can also appear for them, and the senior lawyers should spend some of their time for arguing for the weaker section.
But that's true, sir.
Yes.
But do they really find time to spend for a cause?
They have to find
They have
time.
to, I understand,
Yes.
but do they?
They are not doing that. I am sorry to say that they are not doing that.
So that's where we need to sensitize
Yes,
the
yes,
senior,
yes.
the lawyers who really.
They have to spend some of their time.
Veena, what perspective do you have on this? How can equality before law happen when everything in the High Court and the Supreme Court revolves around who is the best lawyer you can go in for and how much is your paying capacity? So, do you think equality of before law is really being served, or we have achieved that goal, which is marked in the Constitution, which is there in the Constitution?
The question is very relevant. What I think is that that depends on the social commitment and dedication of the individual. Like any other profession, like doctors we see in medical profession, the individuals or the doctor should have that commitment and dedication to the profession. The social commitment should be there. So lawyers should also have that same social commitment and dedication. And what I think is that recently in Kerala we have that Nizam's case in Thrissur. So one poor man was brutally killed, and what I learned is that the advocates who appeared for that man and his family, and they appeared without financial aid or anything. So there are rare or exceptional cases, but even before that, even these cases are brought before the court. How are the poor and the rich treated in the police stations?
That is another. We are just talking of equality before law. My pointed question to you is, should happen, everyone knows, for the last 66 years, this should happen, has been carrying on. What is your proposition? Sensitizing the senior lawyers, the judiciary is already sensitized, but first the case has to come before a judge. Then only a judge will be sensitive enough to understand that he is economically weak. But if the case can't come before the law, before the judge, how do you see this happening, equality before? So are we just paying lip service to this right, or do we really need to move ahead and do something?
See, definitely, we have to critically think about it, and we have to find out some solutions. Like, there are senior lawyers who are really dedicated and socially committed, and who appear for this so-called weaker sections or the poor section of the society. But if you want to move forward, we have to find some other solutions, like senior lawyers
rewarding them,
yeah,
or trying to give them some sort of a Sir, any solutions that are there in your mind?
As a matter of fact, there is a crucial fact which we need to note now. I said that there is a slow but steady progression in the manner of reaching out to the needy litigants. Now, under the present situation, through the National Legal Service Authority and through different systems, in the Supreme Court and in the High Courts, there is something that is called the legal aid scheme for the poor. That is the bottom line, economic bottom line. But you should know that the real bottom line is not the only crippled in economics of justice delivery. There is what we can call it as a middle income group, who are not poor in that sense, but who unfortunately cannot access the high profile.
Correct, absolutely.
Therefore, now NALSA has come out with schemes, and Supreme Court has also got, and even the High Courts have got, what is called the middle income group legal aid schemes. And then the bottom line, the real poverty. But let me tell you one more thing. Designated senior advocates of the Supreme Court and designated senior advocates of some of the High Courts, including the Kerala High Court, are actually doing pro bono in those areas. Pro bono, full free work.
So is there any sort of recognition for them?
Well, I think they have all people who have reached beyond the level of any more recognition.
But still, as a good citizen,
Of course, if some sort of recognition is made, in a way it is not for them, but you project them as icons for the future.
Correct.
You project them. Say, for example, the senior advocates of the Supreme Court, who they really don't need any money anymore,
anything.
but they don't need any fame anymore. But then if you promote them and show, see, look, even this gentleman who has no time is good doing this, why not the next generation
Exactly.
do it? So therefore, he or she, that the great lawyer, can be projected as an icon for the future.
Do you think that could be a way forward?
Yes, that I have said earlier. These type of icons or senior leaders, senior lawyers, they can spend their time, more time for, because they don't need any money, any publicity or anything like that. They can spend their time for the weaker sections, and they will be, they can guide the others also, the youngsters also, in future.
Ma'am, do you think there should be some sort of a scheme initiated by the High Courts and the Supreme Court to acknowledge such work? Because not everything needs really to be done only by the government or the executive of the day. I mean, it's also the High Courts who can do this. So,
there should be a collective responsibility, definitely. The state or the judiciary, the High Court and the Supreme Court, they should work together to achieve this goal.
Right.
So, I think the matter is not the money, but the time for the senior lawyers. See, that is the thing.
but you're doing a very balancing act. You should, you know the reality. The lawyers are not doing enough.
Yeah.
That's the reality.
Yeah.
And all senior lawyers have to voluntarily come forward and do this.
Yeah.
They are making money in majority of their cases, at least 25%. That's the kind of account or responsibility they have towards the...
But my question is, how far we can compel a person? It's
Sir, how far can we compel a senior lawyer to actually get to doing this?
I think we need a paradigm shift in the thinking of the whole society, particularly the lawyering society. I say this at this point of time in 2016, when I feel that we have all understood the Constitution and we are trying to work the Constitution based on rights. But there is something called duty of citizens, which you get in as part of fundamental duties. So it's part of fundamental duty to get attuned to the requirement of the nation.
And that's where we are lacking.
Yes, that's where we are lacking. You lack the motivation because you are aware from the textbooks as to what are the fundamental duties, but are you living up to the fundamental duties?
And duties alone can't be for the lawyers,
No.
it has to be for every citizen.
For every citizen. Now, as far as my little experience, I would say, before I became a judge, I know I had at least 6 to 7 friends, and we were a group where we had a commitment made by ourselves to ourselves, and we did it for ourselves, not to the knowledge of others. We had earmarked about 10 to 20% of our annual income to be spent on pro bono,
Activities.
100% for the poor.
Okay.
And those litigations, we don't even say that these are the litigations which we did, but then we did it for our own satisfaction in the ultimate analysis. So I think this is more a sort of motivation that has to be brought into the lawyering system. And how can you pressurize? Now, there are certain things where you can put up pressure. Some of the high courts, I mean, almost all the high courts have got rules for the purpose of designating lawyers as senior advocates. Some of the high courts, including Kerala High Court, has a principle where we have a look at how many pro bono or how many legal service work did this man do before he applies for a senior gown.
Okay.
You know,
So that was a consideration.
that's a consideration.
We are aware of the rights guaranteed by the Constitution. We are not aware about the
Duties.
as a citizen.
Correct.
The lawyer is also should have commitment
To do this.
to do this.
It's time for us to head into a break. When we return, we'll take up questions from the students here with us. Welcome back. You're watching Raj Sabha TV and this is Constitutionally Yours. Continuing with the discussion, we'll start off with a question. Yes, sir.
My question is to the judiciary. Recently, in connection with the demonetization, there was widespread protest against the attitude of the RBI regarding discriminating the cooperative sector. Doesn't it create a violation of Article 14?
Does that necessarily mean Article 14 has been violated?
See, equality before law and equal protection of the laws. Those principles work fundamentally on equality among equals. Now, whether cooperative societies and cooperative banks have to be treated as equals to the nationalized and private banks
Correct.
is itself a question of equality.
Correct.
So, therefore, you can't have a straitjacket answer and a formula built on Article 14 for that.
So, you would like to add to it?
Suppose I am representing the government or the executive. Suppose we are enacting a legislation or issuing a notification or order which affects the life of the people, poor section, ordinary person or the middle class people. And obviously it favors the corporates or the higher class of the society. It will affect the equality, the rights, Article 14 guaranteed by the Constitution.
That's how you would like to argue it.
Yes, definitely it will affect.
Veena?
Then I think when the case came before the largest court of India, Supreme Court, the court has made many observations, and the court expressed their concern over the affected people, but I think not reached any conclusion.
Correct. And there is where the answer lies. Had they concluded, and they're very good at concluding.
Yes.
The Supreme Court doesn't mince words. In fact, all judiciary, if they don't conclude, that means there is some issue stuck somewhere.
Yes.
Right? That's an indication. Yeah, Veena.
As Honorable Justice has told, whether it's to find whether the cooperative banks can be treated along with the nationalized bank, that's a legal question and that has to be solved out legally. But the thing is that the common man, the common folks in Kerala, they depend or they have deposited their small amounts of money in the cooperative sector or the cooperative banks. So there, my point is that I find the issue there. So there is a denial of justice for the common people. Or Article 14, the question of Article 14 arises there.
I'll just feed in a bit of information here. Cooperative banks and chitty banks, as they are known in Kerala, are a pretty big sector here. And that's how people in this state save their money and put their savings, because there is good return for them in that bank. Yeah, next question.
My question towards the legislature. After the decision in NAS Foundation by the Delhi High Court, the rights of the transgender peoples are very much discussed in public. So, what the legislator preventing from passing a law for protecting the transgender people?
I agree with you. The Parliament has to pass a legislation with regard to the principle laid by the Supreme Court of India. And the transgender, then there are identity problem everywhere. We have to identify with that. The identity problem from the Dalit community, from the women, and even from the transgenders.
Correct.
And Parliament has to take initiative to pass a legislation to protect their rights.
Just to inform you, there is already a legislation recognizing transgenders as the third gender, which is pending in the Parliament. And I have a hunch that it's likely to be, because it's a non-political legislation, it's likely to be passed in the coming few months. Yeah, ma'am, you would like to add to it?
This is a very serious issue that the nation is facing. As she has just rightly pointed out, the transgenders, they are denied the fundamental rights. So they don't have that freedom to move around freely. They don't have that same they don't enjoy the same social life as we enjoy. They are even not allowed to do jobs in private sectors, and now some legislations are being made. So this is a very serious issue that we have to discuss and we have to solve it out. Like Honorable MLA has told, the Parliament has to pass a legislation.
Yes. Sir, you would like to add to it?
I think if you look at it from the provisions of the fundamental rights, it is a cardinal principle that no citizen can be discriminated solely on the ground of sex. Now, we have traditionally understood sex as only either male or female. So, this solely on the basis of sex, I would say it's high time we have to go to the extent of saying, don't question the sexual identity, don't be concerned about the sexual identity, don't do anything on the basis of sexual identity unless that becomes a relevant fact in a particular matter.
Correct.
So therefore, if you make it neutral, because I remember gender neutral, and this gender neutral approach is something which I had been trying to canvass even in writing judgments.
Right.
Why should you say that she and he and that and this and all those
A
things?
citizen is a citizen.
Unless it becomes relevant.
Right.
And if you are trying a matrimonial matter, you may have to say that.
Yeah.
Sometimes I have heard somebody telling me, look, judge, that lady lawyer came and argued the other day. How is it relevant?
Yeah.
It's a lawyer. So therefore, the whole issue is, why are you focusing on the issue of gender unless gender is relevant for a particular decision making? Because this is the same principle that should have. Now, when I see I don't see what more legislation is really required. They need a very powerful protective covenant which puts them at par with all the persons, and therefore this gender neutral approach, there again we will repeat, the mindset problem. You make the law, the executive enforces, the judiciary decides, but ultimately the people don't carry it.
Correct.
If we the people of India don't carry the laws, then who is going to carry it?
Next question.
Question is to legislature. In many of the places religious worship, there are women are discriminated to such entering such worship places. There is any violation of Article 14.
My personal opinion is very clear. It is the clear violation of the Article 14. No doubt at all. It's a clear violation.
So women should be allowed
Should be
at
allowed
all
to enter
religious places.
all religious places.
Irrespective of gender.
Irrespective of gender.
Veena, you would like to add?
Definitely, I also agree with him, no doubt. Because women should, it's a clear violation of Article 14. They should have the right to enter every religious place. So, and again, there are some controversies related to this, that Sabarimala issue and all that. But still, my strong opinion is that women should have the right to enter all religious places.
That's very well said, ma'am.
Yeah.
My question is, but for saying so and for implementing it while campaigning, how much of votes will you lose?
I don't think I will lose any votes, because in my constituency, I have more women voters.
Okay, so you are safe.
There is one purely academic and theoretical matter, because the law students are here. I've always tried to learn whether Article 14 in its complete ethos can be pushed into the protective area where religion gets protected under the Constitution. That's an issue which is not to be debated, but that's something which...
I mean, it's a huge area, sir.
That's right.
To what extent can you
That's
allow
right. Article 14
the Article 14
Why I
equality
say
before
that
law?
why I say that is, where the religious elements of the society, religious content of the society is protected by the Constitution, then what the Constitution says is, you may practice, profess, etc., of religion, subject to public order, morality, etc. So if you don't bring it into category of immorality and against public order, decency, etc., then it stands by itself. Then can you further pump in an erodive material?
So that way, going by that logic, which essentially mean all minority women should be given the right for triple talaq. According to, if you push it to that level, then the minority women whose rights have been really seriously compromised need to be reconsidered also.
Definitely 80 years back, Dalits and backward communities were not allowed to enter the temples in Kerala. Only after 1936 they were allowed to enter the temples. Before that there were agitations attended by the Mahatma Gandhi, also the Vaikam Satyagraha, famous, the Guruvayur Satyagraha. And they were allowed to enter the temple. Just like that. And now the minority women are facing the same issue. I think within the community there should be a demand. Within the community there should be a demand. In Hindu community also, the largest community, the majority community, there were many changes.
So what
Many
you're saying
changes.
is for Hindus the state can do anything, but for the minorities the state should allow the community to decide for themselves.
No, no doubt at all, no doubt at all.
Is that what you're saying?
Everywhere, the right of the women should be protected. No doubt at all.
It should be different.
No, minority women, their rights should be protected. Their rights should be protected. If the talaq is there, if somebody can divorce a minority Muslim lady by saying a
Property
word
rights.
or 3 words,
So also property rights.
property right is there also. And within the community, I think the Constituent Assembly has discussed in detail. As rightly said by the Justice, we have to look into the rights of the religion also. And my opinion is that within the community there should be some demand.
Then only should.
Then
But
only we will
as
be
far
able
as
to, then only the parliament or the legislature will be able to make appropriate legislation.
So, for all practical purposes, the state, as far as enforcing this Article 14, equality before law, should just concern itself with the majority community.
The Constitution itself provided the right for religion, they propagate their ideas and to believe in their religion. It's also providing that. Then we have to protect the religion also. But my opinion is that within the religion there should be demand for reformation.
Okay. So, there are demands. Anyway, Veena, you would like to add to this? Because
It's not
this
a
is...
question of minority or majority. Everywhere, in every community, in every religion around us, there is this issue. So, as our MLA has told, so the women belonging to a particular community or a religion, if she feels that this is injustice, I need justice, she can question that through the courts. And initially I have told a general statement. My opinion is that in any religious places, women should not be discriminated because of her gender. That is my opinion. But I don't like to confine or see this as a majority issue or a minority issue. Everywhere this is there. And what I'm optimistic about this, because as we have discussed here, long 80 years back, this was not the case or situation in Kerala. It was totally different. So changes will happen and this will also change.
The Supreme Court itself intervened in the property rights of the Christian women. The Mary Roy's
And
case.
gave them.
The Mary Roy's case.
Yeah, that's the point. That's all we have in this episode. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.